Fleischman,
Here.
Shining,
Here.
Spyro,
Here.
Judge Yee.
Here. Thank you, Linda.
Sure.
All right, so today we have no invited speakers, time for you all to talk amongst yourselves. We have a very brief PowerPoint presentation where we're trying to give you the right Justice Gap study data that you asked for, instead of the wrong data, and also try to recap where we are, as well as hopefully help facilitate a discussion around the last two remaining issues. Before we do that, we will turn to public comment. And I do see 4 people with hands raised. So
Oh, wow. It's a whole bunch.
So I'll start with Rita Miller. I'm going to be pretty strict about the time limit given the number of people that have their hand raised. So Rita Miller, 2 minutes. Ms. Miller? You'll have to unmute yourself. All right, go ahead.
Okay, thank you. I don't know if you can hear me yet. I hope you can. My name is Judge Rita Miller. I am retired from the Los Angeles Superior Court. I sat on the Superior Court for about 18 years. A very large percentage of my work on the court was in employment law. I tried many failure to accommodate cases and interactive process cases. I sat on the Court of Appeal for over a year as sort of a substitute for somebody who was out. I retired about 2 years ago, and now I'm a mediator. A very large percentage of my mediations are employment related. Steve Fleischman and I have appeared on panels together, and we know each other well. So that's who you're hearing from. I wanted to share with you my grave concerns about having paraprofessionals involved in helping claimants at the accommodation and interactive process stage. The things that happen at that stage are of critical importance to the rest of their case. It may cause them to lose a summary judgment motion. It may cause them to lose their job when they otherwise could have kept it. It may cause them not to recover at trial or to have a greatly reduced amount of money that they get at trial. The issues that come up at the interactive process stage and at the accommodation stage are very subtle. They are very complicated. The law is always changing. It is very hard even for the lawyers to keep up with the law, as Mr. Fleischman is totally aware. It's a very complex process. If they say the wrong thing to the employer, if they say that they are disabled in a certain way, it may foreclose their ability to recover. If they say that they can work in a certain way but not another way, it can have very long-term consequences for them. These people, I have great sympathy for these people. These are frequently low wage earners who do not have resources, who do not have the ability to feed their families, and they are disabled, and their disability may prevent them from working. Whoops, are you raising your hand that I'm done?
Yes.
No, when you're done.
Okay. Not, but you are past your 2-minute time limit, Judge Miller, and so I'm sorry about that. It looks like a couple members of the subcommittee have questions for you. So,
Great.
Stephen, if you could go ahead.
Sure. Sunny, good to see you, even remotely, even with your camera not working. This is a pleasant surprise. I didn't know you were going to be here today. I'm going to ask you an unfair question, and I want you to tell me if it's unfair, and you don't want to answer it, that's okay. But what do you think, I understand your position on employment issues, but our group is also considering allowing paraprofessionals to make court appearances and even try certain types of cases like unlawful detainer cases. Can you tell me what you think the reaction from your former colleagues on the bench would be?
Well, my former colleague, if it's legal, my former colleagues will listen, and some of them will even try to be helpful if the paraprofessional isn't as professional as they should be. I don't think my former colleagues will do anything but follow the law as it is.
I guess I'm asking, do you think your former colleagues would think it is a good idea or a bad idea to have a non-lawyer actually try a jury trial?
I think that 99.9% of them would say it's a terrible idea.
All right. Thank you for answering a loaded and unfair question, Sunny. I look
It's what I
forward.
expect of you, Steve.
Okay.
All right. Ira.
Judge Miller, if the employee has a choice, and only this choice in the accommodation process, and in employee grievances, has a choice of having a paraprofessional, a trained one, trained in employment law, assist them and represent them in speaking to the employer. The choice of that or nobody to assist them or represent them. Do you think it's better that they have the choice to have a paraprofessional?
Well, I think your question assumes facts not in evidence.
Well, it doesn't matter. This is not a court. I'm asking you if that's what the case.
I don't see why a paraprofessional would be any more available to that person than a lawyer on a contingency would be. If that person can find a paraprofessional, they can find a contingency
Your
lawyer.
Honor, Judge, would you please answer my question? Which would be better? This is like the reverse of what happens in court. I'm sorry. I don't mean to be disrespectful.
Oh, I'm not worried
But
about
you're
it.
avoiding my question. I asked you.
No, I'm not.
Yes, you are. Yes, you are.
Okay, don't argue with me. I'm not arguing.
Ira, we do have a number of
I know, but I'd like this
give
judge
public
to
comment.
answer the question, this
Okay.
mediator.
Judge Miller, I don't know if
Your question is nonsensical.
Oh,
because-
Can I
all right,
please
good.
jump in here,
This
Leah?
judge just
Yes.
called me nonsensical.
Ira, I'm going to jump in here because as a member of the committee, I think our opinions are what matter. The opinions of the public members should be expressed in public comment. But we have lost a lot of time that we've never had the opportunity to discuss. So if the more questions we ask with all the 10 people who've raised their hands for public comment, the less time we'll have to talk.
Well, that's true.
So can we just please try to listen to the comments, not ask loaded questions or leading questions because they're not really persuasive to people who are on the committee.
Well, they
And let's
might
just
be.
get to the point where we can debate each other honestly, respectfully as equals.
They might be persuasive to other members of the committee. And also, Steve just asked a question that has nothing to do with our subject.
Right, and it wasn't persuasive because it wasn't a complete question. So let's just kind of move on.
Okay, so Judge Miller, I think you're declining to answer Ira's question. Thank you
Right.
for making comment, and I am going to move on to the next speaker, which is Andy Katz. Mr. Katz.
Hi, good afternoon, committee. Andy Katz, I'm a member of the California Employment Lawyers Association and the Consumer Attorneys of California, speaking as an individual. In prior meetings, myself and other lawyers who have experience handling complex employment disputes, particularly disability accommodations and other violations of FEHA, we've shared specific reasons why this subject matter is too complex and too intertwined with other areas of law. To be able to essentially allow non-lawyers to practice law. This proposal would not expand access to justice. It would just expand the equivalent of malpractice, missed issues, and in some cases, aggravating non-cognizable employment disputes for the benefit of for-profit companies that are seeking to create automated business models without providing quality services. It would help to expand access to justice, to build on existing services provided by legal aid clinics, lawyers, and other community-based organizations that are already allowed to assist people with applying for benefits at the EDD, help people with labor commissioner claims, and participate with DFEH investigations. We need more funding for legal aid. We need more clinical activity with supervised law students. We need to mobilize and require additional pro bono work and connect these resources together to serve people both in the very low income and the low to moderate income ranges. I'm concerned that a private paraprofessional market will not be affordable. I looked on the internet and found an organization holding themselves out as Sacramento Paralegal Services. They have a service fee list that includes something called Family Law Document Review, holding out at $150 an hour. It is supervised by an attorney who is apparently willing to supervise paralegals for hopefully an ethical ownership of a business that is doing family law document review, probate, estate planning, deed preparation, small claims preparation, some landlord tenant. But there is no meaningful attempt to dabble in employment law. It's just too complicated. But what I saw there is that if the prevailing rate for paraprofessionals is $150 an hour,
Mr.
I
Katz,
have just a couple sentences left, if I may.
all right.
It remains unclear what change at all would come from allowing a licensure of a paralegal in employment law. If this program requires operation under attorney supervision, the economics should be about the same. And it's not clear if this proposal accomplishes anything. If it's not with attorney supervision, that exposes workers to serious risk of losing their rights and abuse by predatory practices. So in conclusion, many members of the employment bar would be excited to work with the State Bar of California on ways to bridge access to justice that can work. But this concept may have merit in other issue areas that you've reviewed, but will not be affordable or reliable here. Thank you.
Thank you. Ann Hull.
Hopefully you can hear me and see me.
Yes.
I have a couple quick things to say. I'm a member of the San Bernardino County Bar Association, San Fernando Valley Bar Association, and also SELA. I think pro bono opportunities should be given to new law students. As a new law student years back, I had my very first experience over at Van Nuys Court, assisting in a variety of different clinics that were there. It was a great experience, and I think that we should be taking advantage of situations like that, providing for opportunities for supervised counseling sessions and things like this with young and new attorneys and volunteers as well. Interesting thing came to me, which kind of mirrors what Judge Rita Miller was saying. And I recently had a case where there was a person who'd gone to a company's, what they call it as advice and counsel, under the guise that it's a independent company or an independent process that will help employees with their grievances, which is actually disguised as their HR organization. Anyway, the employee was asked to sign a document in which they were required to state that they weren't disabled. This person was pregnant, and this person had been given a doctor's note saying that they were not allowed to lift more than 25 pounds. The person did not consider themselves disabled. And by signing a document, which was required for them to sign by this quote unquote advice and counsel, which they thought to be an independent firm, that person lost all kinds of rights to protections. And it's just one of many examples where the term disabled to an average person doesn't mean what it means in the law. And I would just recommend that we take more advantage of pro bono opportunities, and maybe even look into a requirement that new attorneys or attorneys who are in their last year of law school, something like this, have the opportunity to clerk or do pro bono work at which they can.
Ms. Hull, it's been 2 minutes, so it's time for you to wrap up.
Thank you.
Okay, thank you. Next up, Eli or Ellie Grinvald.
Eli.
Eli.
Hi everyone. My name is Eli Grinvald. I'm an attorney. I've been a lawyer for about 8 years. First 2 years I was a public interest lawyer. I've been doing employment law for 5 years. I'm honored to speak in front of you. Hi Ira. Hi Carolyn.
I know it. I know it.
So I've been doing employment law, and as the speakers before me said, it's a very complex field. I don't want to reiterate everything they said, but I think it's a bad idea to allow paraprofessionals to handle discrete tasks such as assist non-lawyers with assist non-lawyers and go to court, because employment law is complex. It took me a couple years as a lawyer to really figure out what I've been doing. And even in areas like UD, I've done a UD case, and I have some background in UD, and I needed the supervision of an experienced lawyer, Yelena Pop, to guide me through a trial. And if you go, for example, in court in Stanley Mosque, there's people standing outside who offer to prepare documents for you. I've seen that in immigration where people prepare documents. It's much more than just preparing documents. It takes a while to acquire the knowledge and to distinguish. Well, employment law, unlike PI or other areas of law, is very fact specific. One little fact changes and everything changes. And it's just, it's a very fact-specific, fact-intensive. The law changes, new decisions come out daily, weekly, and to answer Ira's question, even though it was not posed at me, I know my time is almost up.
It is up. Your time is up. I'm sorry.
Is a person better off with a paraprofessional or on their own? It's equal.
Okay, Christina
Thank you.
Coleman, you're up next. Thank you.
Did we lose Carolyn? She's not on the participants group anymore. In the panelists. And she was gone when he said, hi, Carolyn, the last speaker. Eli, I looked there and she was gone.
We'll look for her.
Hi. Sorry, no.
Go ahead, Christina.
I apologize. It did something very weird. It booted me off. I am an attorney. I've been an attorney for about 22 years. And in fact, Ira Spiro was my very first mentor. So hi, Ira.
Hi.
I've been doing employment law for about 15 years or so, and I consider myself pretty skilled in that endeavor, and it did not come overnight. I'm very concerned about the idea of paraprofessionals participating in even the interactive process in reasonable accommodation areas. As a practical matter, I very, very seldom see those issues not already intertwined with other employment issues such as discrimination and retaliation. You almost never see it. They're also extremely complicated, and they are very hotly disputed because they're so complicated. And in fact, the only trials I have had to go to recently in employment cases have been cases that had a reasonable accommodation and interactive process issues because it's very, very complicated. I also think that having a paraprofessional involved even at the pre-litigation stage engaging with the employer is a very bad idea and would be more harmful to the employee than good. The biggest reason is that I believe that if a paraprofessional became involved, the employer would feel the need to get their own counsel involved. So I think right at the outset, the paraprofessional would be outwitted by having an attorney on the other side. I think it would also disrupt the interactive process and the natural flow as intended by the legislature itself. It's supposed to be a direct communication if possible. If you've got an if you've got a paraprofessional speaking on behalf of the employee at the very beginning, when the employee could probably do just as well themselves, and now you've got an attorney for the employer where one wasn't originally necessary, just for a reasonable accommodation, it's going to stall the process, it's going to complicate the process, it's going to eliminate the person-to-person and direct communication that the courts say is the most effective means if it's possible. And I think it's going to be doing a disservice to the consumers and the employees that the laws are designed to protect. You know, FEHA is designed to protect employees, and I
Ms.
think
Coleman,
it's going
it's
to
2
obligate that.
minutes. You could wrap up your comment.
I'm wrapped up. That's all I had to say. Thank you for the time.
Okay, thank you. Next, I have Felipe Cáceres.
All right. Good afternoon, everyone. My name is Felipe Cáceres. I'm with SCIU Local 721. I've been a labor organizer, community organizer, legal advocate, and general good troublemaker for quite some time now. I'm a student of IRA's, and I think one of the reasons that I came here today was to just explain, I guess, from the perspective of a lot of the workers that I organize, exactly what employment law looks like. As opposed to, I guess, what some of the folks' experience has been in the courtroom. Because in my experience, on average, our workers make about $40,000 to $20,000 a year. They have absolutely zero access to any employee rights, basic rights. I mean, I just came from a McDonald's right now that has 7 COVID-19 cases. In which workers have filed about 26 health complaints, numerous ULPs, and all kinds of other community work has been done to recognize this store. McDonald's is doing nothing. The employer will not respond. And that's coming from a union that represents 95,000 public sector workers, including the public health inspectors. So I'm here today just to highlight the fact that I understand that the law is technical. I went to law school for that reason. I understand that there are a lot of backgrounds that are needed in order to understand the complexities and expertise of employment law. But the reality on the ground is employment law isn't available for any worker in this country that makes less than $40,000 a year. So this whole conversation is really moot on a certain level because there's no access. So if you're talking about access, we need more professionals in the field, whether they be lawyers, advocates, or organizers. Thank you for your time.
Thank you. Jeffrey Bills.
Sorry, can you hear me now?
Yes.
Okay, so the Zoom rejoins us when you call on us and the whole program restarts. That's what the pause is, I believe. Thank you all very much for your service to the working group. My name's Jeff Bills. I'm chair of the Beverly Hills Bar Association Labor and Employment Law section. I'm speaking as an individual. I've spent most of my legal career on the defense side in employment law representing employers, but I also have represented employees, and currently I'm focusing more on the plaintiff side. I guess I would like to echo what Judge Miller said, along with a number of the other speakers, that this is really a idea that is fraught with potential perils for the individuals who get these services. This is an ever-changing area of law. I know when it comes to representing employers, one of the first things that we will look for is any way in which employees might not have exhausted what they need to exhaust, might not have filled out things correctly or whatever it might be. And I'm not sure that the paralegal, the untrained professional is going to be sufficiently educated or aware of the ever-changing law and the requirements that go into these often complex cases. I see one of the topics here is workplace grievance ignored, and a workplace grievance can just be so much. It might start as a grievance about an injury or something like this, but then it might involve other areas, including pay or disability pay or leave pay. And then you get into a whole area of whistleblower law that will come up in conjunction with these. You start getting along a wide swath of state and federal law, overlapping laws, and it's difficult for me to see how introducing a paraprofessional into this mix is going to simplify that. It strikes me as an opportunity for these individuals to receive that help to potentially be prejudiced. That's the end of my time. Thank you so much.
Thank you. Sofia Cardenas.
Hi, thank you. My name is Sofia Cardenas, and I'm a program administrator at the Center for Workers' Rights. The Center for Workers' Rights is opposed to the proposal to allow paraprofessionals to practice in the area of workplace grievances and disability accommodations. As a non-attorney at a nonprofit legal service organization, I see firsthand the need for attorneys in employment disputes. The proposed use of paraprofessionals will not fill the gap. First, low-wage workers who already face huge barriers in accessing services have the potential for being exploited by for-profit paraprofessionals who can take no action against their employer on their behalf. Currently, their options are to re-find a private attorney who primarily only charge on a contingency basis or receive free assistance through a legal services organization like ours, neither of which requires a pay-for-service system. Second, attorneys, unlike the paraprofessionals you propose, are able to assess a case based on the entirety of the situation. When the Center for Workers' Rights provides advice to workers, they learn about the client's concerns as well as their goals. We help to determine how to de-escalate conflicts with employers when that is the result that is in the interest of the workers. Attorneys are also able to focus on workers facing a workplace grievance, on those concerns that are actually actionable in court instead of disagreements that have no protection under the law. Paraprofessionals who would be limited in their ability to assist workers would not be able to provide advice that looked at a worker's goals overall. As a result, we oppose the proposal to allow paraprofessionals to practice in the area of employment law. Thank you.
Thank you. Next, I have Jenna Miara.
Hi, good afternoon. My name is Jenna Myra. I'm a directing attorney at Betsedic Legal Services in Los Angeles, which provides free legal services throughout Los Angeles County, including to hundreds of low-wage workers each year. Betsedic has grave concerns about this proposal, and we strongly oppose it. We are grateful that this working group is looking at ways to increase access to justice. Unfortunately, this isn't the way to do it. We want to make clear our opposition to the remaining areas of employment law that the group is still considering, specifically workplace grievances and disability accommodation. And we strongly urge this working group to reject any proposal that would allow paraprofessionals to practice in these areas. We do not believe that this proposal will meet the needs of underserved communities and will only function to further disadvantage the very workers the working group is trying to serve. The following issues remain very real concerns for us: that advocates trained in narrow areas of advocacy will not be able to adequately or competently issue spot complex legal issues. It's rare that clients present with discrete single issue matters. That vulnerable low-wage workers can and will be easily preyed upon by unscrupulous advocates without consequence. That even well-meaning advocates will do more harm than good because they lack adequate supervision and cultural competency. That this is a misguided attempt to address the dearth of union representatives in a post-Janus world by attempting to assist workers in grievance processes, which is yet to be defined, and that critical resources will be diverted away from legal aid organizations, and that legal aid advocates will be hampered in our ability to engage in meaningful policy advocacy. The State Bar and this working group is admirably attempting to expand access to legal services through innovation, and we are fully supportive of this as a goal, but we're concerned that you're not taking this opportunity to incentivize advocates to pursue careers in public service by creating financially viable pathways to practice public interest law as a career. Thank you for your time.
Thank you. Chris Dolan.
Hello, my name is Chris Dolan. I'm an attorney in the all over California. I've been practicing for 27 years. I'm the past president of the Consumer Attorneys of California, the San Francisco Trial Lawyers Association, and I am very familiar with employment law. And there are a few things I want to point out that I think are perhaps not recognized as risks of this. The first being, if you have paralegal services offering to help people, they may not go to the governmental services that are already available to them, like the Labor Commission, like the EDD, like the Department of Fair Employment and Housing. There currently are staff members there for screening and to provide legal services. If you have paraprofessionals saying, come to us, people may be paying for things that the government is already providing them. And we are, as plaintiffs' lawyers, judges and filters of bad cases. So if someone calls me and tells me they're having a problem with their boss, which happens frequently, I may see there's no law against having a bad boss or a bad decision. A paralegal might charge someone a ton of money to file some sort of complaint or grievance, but we act as filters in terms of making sure that the system is efficient. As far as a paraprofessional trying a case, that would be like having a paraprofessional try to be a judge on a case. There are just too many rules that relate to evidence, that relate to process and procedure, that putting someone in that environment who is not adequately trained would result to an insult to justice. This is not the way to make access to justice available. I think it would result in more injustice. Thank you for your time.
Thank you. Our last public speaker, oh, we've got a couple more. I am going to cut this off at 5:45, I think, but we've got Jennifer Ostertag. Go ahead.
Good afternoon. Good afternoon. My name is Jennifer Ostertag, and I've been an attorney for over 20 years. I practice primarily employment law with the Genie Harrison law firm. I'm a member of several bar associations, and I'm an occasional volunteer with the Walala Women's Clinic, which we provide free legal services to women. I've been listening to this meeting for the last month or so, and what has occurred to me is that the goal of the program is really to provide access to justice to low income and middle income individuals. The solution is not to create paraprofessional who will be charging these people for money to provide them with legal advice. But first, it is to fund more legal aid. And the second thing is would be maybe to require new lawyers to complete like 50 hours of pro bonos when they get admitted to the bar, similar to what New York has, and also maybe ask existing lawyers as part of their every 3 year MCLE to perform 25 hours of pro bono for the community. And so if you look at the numbers, I did a quick calculation. We have in California about 190,000 active lawyers. If you have to ask these active lawyers to do 25 hours of pro bono work for the community, and it could be through a bar association or to legal aid or even to the state bar, that would be 4,750,000 of free legal advice that you would be supplying to the community every 3 years. That's my comment.
Thank you. Martin Ahrens.
Yes, hi, good evening. Can everybody hear me okay?
Yes.
I just wanted to thank you for addressing these issues. And I think that I want to echo the comments that have been made. I'm a lawyer. I've been practicing law for 16 years. I've had my own practice for 11 years. And for 14 of those 16 years, I've focused solely on employment law. I'm also currently on the executive committee of the Consumer Attorneys of Los Angeles, but I'm speaking on behalf of myself. What I've noticed in these situations is that in the interactive process and reasonable accommodation, the law talks about how the goal is so that there isn't a case, so that there isn't a trial, so that the employer and the employee can work collaboratively together. And it talks about when there's a breakdown in that process is where liability will hinge. And my fear is that by injecting a paraprofessional, a legal person, into this interactive process, which I've had clients come to me and ask me if I could participate in, and when they've asked their employers if they would allow that, universally, we've been told no. And I think that that's a good idea, and that lawyers and paraprofessionals should not be involved because it makes it litigious and it makes it confrontational. And it hinders the ability for an employer, like a manager, a supervisor, and the employee, the people who really have their, hands on the keyboard, their hands on the tools, and are dealing with these situations and know that workplace intimately and intricately, to be able to come up with solutions and ideas that otherwise might not have come about had there not been an interactive process. So I would encourage this committee to continue to explore for other ways to provide access to justice, but I'm not sure that this is merely just a solution looking for a problem so that we can say that we did something. And I would encourage the committee to shelve it as it pertains to grievances and reasonable accommodations interactive process. Thank you.
Okay, thank you. Our last comment will be from Genie Harrison.
Hello, can you hear me? Oh, good, thank you very much. All right, Genie Harrison from Los Angeles. And again, I practice employment law and am the president-elect of Consumer Attorneys of Los Angeles. And I do want to draw everyone's attention to something that I don't believe has been discussed before, which is information about the Department of Fair Employment and Housing, the State Bar's sister agency. The DFEH has a vested interest because it administers disability law and sues employers based on violations of the law, which overlap explicitly pursuant to the DFEH's website and publicly available information, explicitly overlaps with federal law and EEOC guidance. And per the DFEH's website, the standard is, quote, the interactive process requires an individualized assessment of both the job and the specific physical or mental limitations of the individual that are directly related to the need for reasonable accommodation, and requires an ongoing, continuing communication, which often, in my experience in these cases, occurs over the course of months if there is an ongoing event or physical limitation or emotional limitation. And I really want to draw your attention to the fact that the DFEH's 2018 annual report shows that disability cases account for 1/3 of the complaints filed with the agency and of the lawsuits filed by the DFEH's legal division. There is no single other protected class that's pursued as often. And approximately 5,390 or 39% of DFEH complaints filed with the agency in 2018 involved disability issues. 25,000 of the right to sue notices. Yes?
It's 2 minutes.
I'll just finish, thank you. Of the right to sue notices issued by the DFEH in 2018 involved disability. And in 2018, the DFEH settled 792 cases for a total of just over 13.5 million. If you just look at 1/3 of the settlements, that's 4.5 million of the DFEH's 2018 revenue that could be implicated by the paraprofessionals handling the interactive process and reasonable accommodation issues.
Okay,
So I
Ms.
suggest
Harrison,
that
it's
there's—
really time for you to wrap up.
Thank you.
Okay. Thank you. All right, Steve.
Oh, I had a question for Ms. Harrison, but I guess we can move on.
Okay, if she can also be promoted back to answer a question. But in the interim, why don't we get started? I defer to the group. I do have a few slides, one of which is to kind of review where we were, where we are in the process, the decisions that you've made so far. And the other slides have to do with the provision of justice gap study data, but we could also skip the slides for now and have a conversation, just engage in a conversation.
Leah, I got to make a note again. These slides were not, how many slides are there?
I don't, like 4.
Okay. I just don't find it credible that you're making these, this morning. You guys—
We are, Carolyn.
You are?
We have family law today. we have every working group is meeting once a week. So we have 3 meetings a week, and every work subcommittee is asking for data and information, and it's not all the same, as well as subject matter experts to come and speak. Plus, we're trying to draft memos for you all to review for the meeting next week. So I can assure you this wasn't even made this morning. It was around 4 o'clock.
Again, yeah, not to belabor this too much, but I've requested over and over and over again that the materials we show to the public be distributed to us, because I've just seen this before, and there has to be a way you can put this on the website so people of the public, I believe this Zoom is a new thing, but if people were here at a public meeting, they would get handouts or they'd be able to see it on the screen. I'm told that people who are just attendees cannot see these on the screen. And I've had trouble over the last couple of weeks because the areas on the bullet points jump around, just even figuring out what areas we're voting on. So I'd really, I want to reiterate and request again that we get these slides in advance. It's really crucial to having a
Okay,
quick
Carolyn,
discussion.
I got it. I'm really trying. So for this one, we didn't do well. We are trying, and I understand your concerns. I am not clear as to why members of the public could not see a PowerPoint. We do not hand out PowerPoints at in-person meetings, so people would see it on the screen at an in-person meeting. They should be able to see it on the screen here. So let's move on. Linda, if she has not sent this out, she will. It will be in the Dropbox. And I want to ask the group, though, why don't you just go to the first slide, Linda? So these are all the things, it's our understanding that you have touched upon all of the employment-related issues that were identified, and all of the ones that have been touched upon have a check mark associated with them. The 2 remaining outstanding issues, as I understand it, are those at the bottom of the slide. Does that comport with everyone else's understanding?
No, my understanding is unemployment benefits is still unresolved. My recollection is we voted all the other ones out, and we're debating these 2, but unemployment, we never came to consensus on, and it sort of got kicked back to the Income Maintenance Committee.
So unemployment, the administrative agency proceeding was addressed by the Income Maintenance Committee prior to the last meeting. There was a recommendation that was approved by the full working group that EDD proceedings be included in the paraprofessional program. With wage and hour claims, there were also some related recommendations, both from the income maintenance group and general civil. So I think maybe what we should do on wage and hour and unemployment is denote them with a different kind of bullet point or asterisk saying more discussion needed. So with that, then it sounds like workers' compensation, unsafe working conditions, unfair termination, everyone agrees that they're not going to be included in the program.
And sexual harassment or unfair.
Yeah, sexual harassment. Wage and hour and unemployment, more discussion needed, particularly as related to the recommendations that were already moved forward from general civil and income maintenance, respectively. It may have helped those flipped. And then the outstanding issues are denial of accommodations, workplace grievance not adequately addressed for this subcommittee. Is that right?
I believe so.
Okay. So I have the Justice Gap study data that you all requested, but I don't want to just keep talking. You haven't had opportunity to talk. So I would love to address.
I'd like to address Erica for a few minutes because I'd like to try to get some resolution on this. Erica, there are 3 points I'd like to make to you. Number 1, 4 meetings ago, we voted 2-1 to eliminate these topics, and you wanted to hear more about it, and we agreed to that. Since then, we have, to use your words, been inundated with witnesses, virtually all of whom are against this program. I thought Ms. Davis had some interesting observations and ideas, but ultimately she came down against including this. I'm admittedly biased, but I thought Eric Schwetman was the best witness we had because he gave a more fair and balanced view of the issue in a non-Fox News type of way. He said, yes, there could be some situations where a paraprofessional could help, but he said, we're never going to be able to draw the line between where they can and where they can't. And you pointed out that something you think is on one side of the line can very easily actually be on the other side of the line. In other words, the 15-minute, you're muted, Erica. Someone wanting to leave 15 minutes early could on its face just be about wanting to leave 15 minutes early, unless the employer is letting all the white people leave 15 minutes early, but not the persons of color. That's the point I'm trying to make. All right, you have heard, the reason I asked Eric and Laura Weatherford to come was I wanted you to hear from some defense attorneys, because it's very clear that the plaintiff's bar is organized in a meaningful way against this. I'm telling you, as a defense attorney, it is rare that defense attorneys and the plaintiff's attorneys agree on substantive matters, particularly in the area of employment. The stuff we agree on is like a bill I worked on a few years ago. Okay, we're going to give judges 75 days to rule on new trial motions instead of 60 days, sort of the procedural stuff. The fact that the plaintiff's bar and the defense bar are both telling you that this is a bad idea, I want you to consider that maybe that means this is a bad idea. But it's not just the plaintiff's bar and the defense bar. The public interest bar is coming before this committee saying this is a bad idea. The second point I want to make is one thing everyone agrees on is this is an incredibly complicated area of the law. And Ira has raised a valid point that you have to think about how much training is going to be necessary to get paraprofessionals qualified to deal with these issues and to counsel clients. And to me, it's going to be a lot in this area. It's going to be several hundred hours of training at a minimum, I think. And I think when we get into the training and regulation part of this, what we're going to find is, and Leah has indicated this in the past, that the more training and regulation there is, the more barriers to entry there will be. And what happened in Washington could be repeated. The third point, you're not going to like me bringing up, but I'm going to do it, is politics. I am telling you as a defense attorney, if these two areas are a poison pill for the plaintiff's bar, and they will use all of their power to kill this, either in the public comment process or in the legislature. And I know as a judge, you don't want to get involved in those things, and I get it, but I just ask you to consider this. I'm pretty sure Carolyn and I are no votes on this. We have spent a tremendous amount of time on this. I'd like to bring this to a head, and if we can vote 3-1 to exclude these two things, then I think we're done, except for those other two areas Leah mentioned that are sort of wobblers. So please give us some guidance where you are, Erica, because we have spent a tremendous amount of time on this, and I think we are where we are, and I'd like to take some votes and get rid of these two. Thank you.
I'm just asking for a point of order to see if it's appropriate for me to address that at this time, or if other people want to have more of a dialogue, because I might be cutting off dialogue by responding.
Well, I'd like to make some comments.
Okay. And then I also have some process issues as well before I even respond to the substance.
Okay, go ahead, Ira.
Okay. First, I think Steve gave a pretty fair summary of what's going on. I want to make, let's see, my first point is this. I think it's pretty clear to all of us that the plaintiff's bar and the defense bar, and it's interesting distinction, but probably valid, the nonprofit bar are against this. And sometimes they're against it for things that are no longer on the table, like they're going to follow up a lot, they're going to be in a lawsuit and follow it up. What bothers me about all that is that naturally a bunch of lawyers are going to be against non-lawyers entering the field of law. Now, I don't mean that the plaintiff's bar is worried about competition. That's not what I mean. Or anything about the defense bar worried about claims against their clients. That's not what I mean either. It might be true, might not be true, I don't know. But my point is this: lawyers, me included, but I'll tell you in a minute, sure have a big bias, not an intentional one, a natural one after years of study and practice. Bias that means in their minds that it's only the lawyers that really could learn how to do what lawyers do. I think that's a really bad thing. And to many non-lawyers, and I've heard from them, it's a rather offensive thing. I don't know what it is, but ever since I was even in law school, I've been kind of against that. I remember one of my professors said, lawyers think they're the smartest people in the world, but folks, they're not. I'll never forget that. But and it bothers me about the process that we've had in our working group. I think there are no lawyers in our employment panel, no non-lawyers. And I think there's only one non-lawyer in the whole working group. Maybe there's two. Somebody could tell me. Maybe Linda looks like she's leaning forward to say. That's bad. That looks bad for the public. And not only does it look bad, it is bad. And so all the scores of minutes, the hours and hours of advice and comment we've had, it's near, except for my former student Felipe and one or two other people, it's been all from lawyers. All right. That said, one of the lawyers who spoke today, Christina Coleman, who I've known for 25 years and is one of the best lawyers I've ever met, she persuaded me of something. But actually, I need to ask Steve if it's true, if she was accurate about it. I think Steve is the one who would know, but maybe others would know. Christina said that having a paraprofessional in the room when a employee is engaging in the interactive process with the employer, she said that would be harmful because the employer would get defense counsel involved. It would get their own lawyer involved. And then it would be too adversary in the interactive process. And I'm wondering from Steve whether, in your experience, Steve, whether that it is likely to occur, that they'd get a lawyer in the interactive process, the paraprofessional can be there.
I agree with her comment, and Laura Weatherford said the same thing 2 meetings ago.
Oh, she did?
Want the interactive process to be an informal process between the employee and his or her supervisor.
Yeah, she
And
did say that.
this would be seen as escalation. And if you put on your management side hat, if all of the second somebody lawyers up, okay, you're going to have to get counsel, and the informal process is going to be at risk. Is a polite way to say it.
I just remembered something. You're right. That's what she said, and I just remembered something that I and I think some others had a really negative reaction to what she said, as if the employer and the employee are there on equal footing. I mean, that's preposterous for nearly all employees. They're afraid of the employer, and they're very shy to speak up with the employer. And the lower down in the pay scale you get, and the more you have people of color, the more likely it is that they're going to feel that way.
Well, as an employer, I take great offense to that. I'm a partner in a law firm. We have secretaries who have issues. We work very, very hard to accommodate them with their issues.
See, that's a lawyer's and an employer's view of it.
I think I am like now. Maybe it's time for me to jump in now. Unless Ira, you have anything you haven't
well,
said
yeah, I have
because you two are getting
completely
into
other point.
That's good.
Right. Now we already have union reps, also called regardless, we already have union reps who advise and represent employees in all kinds of dealings with the employer. I advocate that we have paraprofessionals who get the same training as a union rep does get. There's plenty of programs for it, and they teach the law. I sent in something about it earlier today to the group. And the union would pay for them. I talked to Felipe, my former student, who's the union, he's an official, being not a high executive, but he was very enthusiastic. He said that the unions would employ these people. And so I think that, so the employee wouldn't have to pay for it. I think other nonprofits would do that too. I think that the paraprofessionals should, at the very least, we should authorize them to advise the employees in these two areas we have: workplace grievance, denial of accommodations. In non-union shops, they got their reps in the union shops. And if they're just advising, then they wouldn't be in the room when the meetings go on with the employer. So the employer wouldn't have a reason to bring their lawyers in. But at least the employee would have someone to advise them, as opposed to nobody advising them. And while, the last lawyer who spoke, I remember a week ago, pardon me?
Genie Harrison, I think it was.
Yeah, she said that she does advise employees for free. And certainly that's true. And I do that too. But I don't think a whole lot of lawyers do that. And I think it's even beyond the scope of the nonprofits to do a lot of that. I mean, not the scope, the ability of the nonprofits to do a lot of that.
Leah, are we going to have a chance? Because I know I read.
Yes, you're going to have a chance.
Yeah,
yes, you're going to have a chance.
I think.
Let me finish.
Well, Ira, you've been going on for like 10 minutes, so could you please wrap it up so we can also speak?
Yes. I'm the only person speaking in favor of this, so pardon me for 10 minutes.
That's not true.
Well, all right. I'm nearly the only person speaking in favor of this, so pardon me for the 10 minutes. But anyway, I have one completely different point. It's been argued that we shouldn't be the first state to include employment, the area of employment for non-lawyers. We won't be. The family law group heard from I think he's the executive director of the Arizona courts last week, who was wonderful, I thought. And their program, which will go into effect sometime in the next 9 months, I guess.
I think you're off the point now, Ira.
What?
I think you're getting off the point.
I
No,
think
I'm not.
he's just saying that it would be inaccurate to say that if employment is included in the California paraprofessional program, that would be the only program in the country that included employment, pointing out that the Arizona AOC intends to include employment.
Yes,
Ira,
they do.
with that, let's move on. Judge Yu and then Carolyn.
So I'd like to start with some process issues. I know Carolyn has been frustrated, but I find the tone that is being used when she addresses staff to be really distressing to me. I think that staff is working really hard. Aaliyah has stated some of what's been going on. I feel overwhelmed with these meetings that are going, quite late after a really long day. And so I just wish that we could be as respectful to people as possible, particularly staff. Because in my view, the staff is powerless. We can tell each other you're off point. We can you guys have sent each other snarky emails, but we should never treat staff in that way, and we should never address them in the tone that I have heard over multiple meetings from Carolyn. So it has been very distressing to me, and I feel that that needs to be raised. There's also been statements by Carolyn that are not true, and about things being last minute, and she doesn't know what she's voting on, and that is concerning to me as well. So I have asked the people who are appearing as attendees if they can see the PowerPoint slides. I asked Mr. Dolan specifically, I don't know if he can respond. I know him, he tried a case in my department. I trust him. I asked Miss Jenna Mira from Betzetic, I would like to promote them to see if what has been represented about the PowerPoints not being viewable by the public to be true, because I'm concerned about the process that has been used so far. So can we please do that?
Sure.
Yes, I just started with Mr. Chris Dolan, Judge Yu.
Thank you. Mr. Dolan, can you hear us? I'm not sure if he's still there.
He's there. He just unmuted himself.
Yes, I'm here.
Mr. Dolan, how are you?
I'm fine, thank you. Good to see you.
Good to see you too. Can you see the PowerPoint?
Yes, and I would have answered you, except only chat can come in your direction, not from us back to you.
I figured you would have. As I said, I trust you, so I know you would have. So thanks, Mr. Dolan. So that is something that is not accurately stated. The public can see the PowerPoints. Now, with respect to the subject at hand, I am just to take care of the suspense, if there is any. I think that we have really had a good airing of these issues, and I think on balance, these two issues should not go forward in the funnel. I was so persuaded by what Mr. Felipe Casares said, but also by what Mr. Dolan said. He brought some points that had not been raised, and then I think it was Genie Harrison who was giving us statistics from the Department of Fair Employment and Housing. So that's going to be my vote. It sounds like it's going to be 3-1 or maybe 4-0. But I have some other things I wanted to say, which is that I think part of the process of what Ira said, and I have very much respect and agreement with a lot of what he said is true. It's very hard for us as legally trained minds to understand and even imagine what it would look like if we had paraprofessionals. And some of the comments, and I agree with what Ira said about Ms. Weatherford, some of the comments have really been from an area or a place of white privilege. Like she said, why don't they just take the exam? My sense is that although someone said that there wouldn't be culturally competent, my sense is that people who would be paraprofessionals maybe have less access, less opportunities, maybe not. But I would think that if lawyers could be culturally competent, so could paraprofessionals. If lawyers could be competent, so could paraprofessionals. If lawyers could be trained, so should and could paraprofessionals. I just don't think that these two issues should go forward for all the issues and reasons that have been said. I also understand that the the leadership of the bar has agreed that this is something that they would like to do. And so that we are trying to do some investigation and give them recommendations. So the comments trying to dissuade us from doing this program going forward, they're just not that helpful because it's not our decision. And then the comments about, well, the money should be going to legal services instead. I personally agree with that, but that's just not what we can decide. So going forward, I'm not sure those comments are as helpful. So that being said, don't want to take up too much time. I hope that we can move forward in a way that is respectful of each other and particularly of staff. And if we do not, I will speak up because I don't think they should take it, and someone needs to speak up for them.
I make a motion to exclude these two topics. Is there a second?
I second.
Right. Linda or Araya, can you take the roll call? You're muted, Linda.
Although I do want a chance to respond to what Judge Yu said, because it's very serious, and I do want to say something.
Should I go ahead and proceed with roll call, Leah?
Yeah,
or should
go ahead.
Okay. Judge Yu?
I get to vote first?
Yes.
Okay.
I'm just going, yeah.
Okay, I'm used to being last, but I agree. With the motion, yes.
Spyro?
No.
Shining?
I'm in favor of the motion, correct.
Fleischman?
Yes, and just to clarify, the motion was to eliminate these two categories from the funnel.
Yes. The motion carries.
Okay, Carolyn, go ahead.
Okay, first of all, I just want to say and apologize to Linda and Leah and anybody, and I'd keep this really brief. If you've been offended and if I've been brusque on you, I'm very sorry. I am a very brusque litigator. It is one of the things I have struggled over 30 years to try and rub off those rough edges, and I do apologize. Towards that end, I think the points that I'm making about process are nothing more than trying to have an open and fair process. We can't talk to each other. We've been discouraged from talking to each other, and the law says we can't talk to each other as committee members in between these public meetings. So, you know, there's only one time I can bring these things up, and it feels rushed. So I apologize if I'm rushed. If I seem rushed, I apologize if I'm rushing, but I'm trying to make the process such that we all can feel comfortable, that the public has a chance to really get into and think about these very meaty issues. So again, I'm sorry if I came off that way, and I will do better in the future.
Thank you so much, Carolyn.
Erica, I just wanted to thank you for your comments.
Thank you.
So, 6:13, this is remarkable. Let me talk to you all a little bit about what I would hope to do for next week's meeting. I hope that we will be able to present a memo outlining your recommendations on the subcommittee's behalf. That means we have to have it drafted and sent to you and finalized before the meeting next Tuesday. Reflecting your decisions around everything other than wage and hour and unemployment benefits. What we would indicate with respect to those two would be that more discussion is needed, particularly to review the related recommendations coming from income maintenance and general civil, because we're not going to do that before next Tuesday's meeting. Ira, as we're going to in family law present a memo that has multiple options for representation in court, because there was not universal agreement. Happy to work with you if you want to have a separate recommendation regarding denial of accommodations and workplace grievance. So we can work with you to get that drafted, so the memo would reflect the vote, the majority opinion, and then essentially you would have your minority opinion. Okay, so we'll do that. Does that work for everybody as an approach?
Yes, but I have a request, Leah.
Go ahead.
As part of the materials you send us, can you send what you believe to be what was approved as it relates to wage and hour and unemployment benefits, so we can so we can have that fresh in our mind as we review everything?
Yeah.
Okay.
Linda, in fact, is that, I can't remember if you added a slide here with that information.
My recollection on
I
wage
did
and hour.
not, but we do have the motions that were voted on at the meeting on June 30th.
Okay, well, we'll just send it out.
Yes.
Okay, I got it.
Thank you.
And then what we had also for today, but I'm thinking that we don't need to go through it today, was that follow-up with the Justice Gap Study data. We did put on the agenda for next week a section where we're gonna just do a refresher on Justice Gap Study data, reflecting all of the requests that have come from all of the different subcommittees. I'm thinking that would be sufficient. Today's we had done the deeper analysis of, for those who got legal help in the areas of denial of accommodations and workplace grievances, what kind of legal help did they receive? I don't know that it's relevant given the vote you've just taken. So happy to skip it now and just show it to you all next week, or however you want to proceed.
I would say include it in the material for next week, but we may or may not spend a lot of time on it.
Anybody disagree with that?
But thank you for doing it.
Yes, thank you.
All right. Okay, and I think with that, we're actually able to end this meeting early.
Can I make one last comment to Erica?
Yeah.
Erica, I know you didn't like my question to, her name is Rita Miller, but she goes by Sunny. I know you didn't like the question, but I didn't know she was going to testify. And the reason I asked it is I know her. I've spoken on panels with her. I've had drinks with her. She is in addition to being an incredibly smart lawyer and judge, she can be candid. And I wanted to get a candid answer from a judicial officer on something that's bothering me. I understand you thought it was off topic and you may not have thought it was in good taste, but I wanted to explain to you where I was coming from on that.
Thank you, Steve. I just didn't think it was complete, because if you ask a bench officer if they would rather have a paraprofessional or a self-represented litigant themselves, you know, that might have been, have more weight with me, because it just wasn't comparing that.
And if I had more time, I would have, to formulate a question, I would have tried to have done a better job.
Because we will always want lawyers, right? And that's what I understood her answer was coming from. But if you have a lawyer and you have a self-represented litigant, or you have a self-represented litigant and a paraprofessional, what would be better? So I think those are questions that we will all encounter together and hear from other people.
Thank you, Erica.
Thank you.
Right. And just to close, I will say we are working really hard to try to get true consumer voice on this working group. And it's been tough. I want to acknowledge Ira, Judge, you've made those comments consistently. Been really hard. So just want to acknowledge that.
Thank you. But the people who have done the work in other states has been very helpful. Those comments have been helpful.
All right.
Yeah.
All right. Thanks, everyone. Have a good evening.
Thanks for all your hard work. Take care. Thank you, Carolyn. Bye, Betty.